And last, ninth, climate courts, dispute settlement, and a global court is much needed. And I'll come to that as we go on. So please remember, ladies and gentlemen, climate justice is not just an aspiration. It is a structure we must build with intention, urgency, and collective resolve led by our own hands. The future of our planet depends on climate justice, structure we build today. Here are some of my humble suggestions, and I'll share how we go about it. And this is all how we look at things sitting in the court and dealing with matters that come before us, and that's the thought process that's gone into all this that I'm saying and sharing with you today. So traditionally, courts in the global south have approached environmental justice by holding domestic polluters accountable through penalties and regulations. That's how it all started way back in the 80s. There was a polluter in the country, and we would, pass sanctions, issue penalties, shut down a factory which was polluting. But we could identify a polluter that was there in the country. Time of environmental justice in this country, 80s and early 90s. We applied principles like polluter pays principle, public trust doctrine, intergenerational equity, precautionary principle, etc., and dealt with the issue. That was a whole body of environmental justice at the time. And then you enter climate change. With climate change, the primary polluter often lie beyond national borders, shifting the focus from the local enforcement to addressing adaptation and loss and damage. There is no polluter here. It's outside our jurisdiction. The whole paradigm shifts in climate justice. We need to look at multi-sectoral issues dealing with agriculture, irrigation, whatnot. So this transformation makes climate justice a multi-sectoral issue and a larger issue compared to judiciaries in the north. Judiciaries in the north are simply looking at mitigation, which is emission control. We're looking at a very broad canvas in Pakistan or global south. This transformation makes climate justice a multi-sectoral issue for the global south. The ambit of climate justice, which largely rests on adaptation, now includes water security, agriculture, food security, disaster risk reduction, health, urban planning, infrastructure, ecosystems and biodiversity, energy, finance, and capacity building. The scope totally changes. As a result, the scope of the climate justice for a judge in global south is far broader than a judge in the global north, where legal frameworks primarily regulate emissions. So jurisprudential trends. Let me just, before I go on to the more meaty areas that I want to talk about, just to give you a sense on what the courts have been doing and some of the trends that we developed. I'll not go into cases, but I'll talk about what trends came out in the last 20 years or so. So first of all, when we started dealing with climate cases, we came up with adaptive jurisprudence, and that's what we coin it as. Why adaptive jurisprudence? Because it deals with adaptation. It is not mitigational jurisprudence as we have it in the north. We have adaptive jurisprudence, which is unique to global south, and especially Pakistan, where some of the judgments have had a global acceptance also. So number one trend is the adaptive jurisprudence, pushing government to adapt as opposed to mitigational jurisprudence. We came up with a model of setting up commissions to deal with this. All our cases dealing with climate change deal with setting up commissions. The courts can't really, deal with all these issues during the court hours. So we came up with setting up commissions, as a climate change commission, a smoke commission, or Hubara Busted commission. There are a number of commissions. That's the technique Pakistani courts have adopted. And those commissions have a unique feature. Because the court can't really spend that time in understanding how to go about it, I call it participatory justice. We invite the government, who becomes part of that commission. We have international experts come sit in that commission. It helps as a capacity building for the government as well, and they understand what solutions are best to take the agenda forward. And it is more or less inquisitorial jurisdiction rather than adversarial jurisdiction that says. So commissions have been rather unique in our climate justice jurisprudence, and that's how we've approached these matters. Let me just share with you that the first case that came was Asghar Laghari case when I was at the High Court. It just landed in my court. And a farmer simply said, "Sir, this climate change is coming, and it's going to bring droughts here, and I'm going to lose out on my agriculture. And there is a climate change policy that the federal government has, which is lying on the shelf. Nothing has been done about it. Please push the government to do something about it. So we issued a mandamus, and I still remember that the government that came at that time when we set up that commission had no clue what climate change was all about. They had just heard about global warming, and they said, well, climate change 101, but that's about it. They had no sense and idea on how to sort of deal with the issue. So we set up a climate change commission with IUCN and WWF and others sitting there to capacity build the government as to how to go about it. And by the time I left the High Court, 60% of those short-term policy matters were actually actualized and looked after. Because of that commission, the government understood how to deal with this because the experts were sitting next to them. So in a very participatory kind of a process, we dealt with that. The third ingredient that comes out of our jurisprudence is human dignity. The whole thing rests on human dignity. The entire jurisprudence is anchored in human dignity. At the core of human dignity is the autonomy of the individual will, recognizing man to be a free agent, possessing freedom of choice. Dignity is universal and intrinsic to a human being. Climate change affects all aspects, essential aspects of person's life, raising issues of water security, food security, health security, and energy security. With all these insecurities, a person's ability to design his own life, his plan is weakened, and his ability to make choices becomes difficult. Climate change can diminish individual and collective quality of life, and with it, human dignity. And that's how we look at it. And that's why the court interfered on this fundamental right, which is non-negotiable under our Constitution. One of the strongest fundamental rights that our Constitution has is right to human dignity. We went further. We said we need to now talk about dignity of nature. Let's get rid of this human aspect and let's move on. And we talked about dignity of nature because human dignity is therefore incomplete if it does not factor in dignity of nature. In upholding the dignity of nature, do we actually uphold human dignity? So that's the step forward that we went. We also changed the approach on deciding matters. We went into biocentric approach in attending to issues. We said there has been a recent rise of jurisprudential thought which rejects the false dogma of humans over nature and instead recognize our interconnectedness with natural world and acknowledge its rights to exist, persist, and maintain its vital cycles. The transition from an anthropocentric approach denoted by the right to the environment to a biocentric approach constructed around rights to nature. That's been a paradigm shift in our approach on the judicial side. So we also gave nature a legal personhood. Granting nature a legal personhood is a transformative step in environmental protection, recognizing ecosystems as rights-bearing entities rather than mere property. This legal status allows rivers, forests, and other natural entities to have a standing in court, enabling legal action against environmental harm. The key advantage is that it shifts the focus from human-centered exploitation to ecological preservation, ensuring that environmental interests are directly represented. So countries like Ecuador, New Zealand, and Bangladesh have already implemented this approach, leading to stronger conservation efforts and accountability. We've also introduced, and that's now very close to my heart also, Islamic environmentalism. In one of our recent decisions, we've gone back to the Holy Book, the Quran, and looked at that how, 90% of it really talks about environmental issues. And that wisdom we brought into the courtroom. And if you see the recent judgment, it talks about, for example, I'll refer to it, the concept of Tawheed, unity of God. The Quranic concept of Tawheed underscores the idea that all things come from one creator. This perspective encourages holistic approach to the environment, viewing the earth and all its inhabitants as interconnected and interdependent. Stewardship, Khalifa. The Holy Quran emphasizes that humans are stewards, Khalifas on the earth. This concept promotes responsible management of the earth resources. And we also thought that we might connect with people. We've been coming up with environmental jurisprudence for years. But now with religion coming into it, so it's culturally so deepened, we could understand that we could relate to people when we were talking about these things. Talk about balance, mizan. The Holy Quran speaks about balance in creation and warns against upsetting this balance. Climate change, which is driven by human activities, is disrupting the earth's natural balance. Avoiding waste, says the Quran, israf. Islam discourages wastefulness. The current pattern of consumptions and the waste, especially in more developed countries, are contributing significantly to the greenhouse gas emissions and climate change. And finally, justice, adl. Climate change is also a matter of justice, as it disproportionately affects the poor and vulnerable people who often have contributed least to the problem. So this jurisprudence was brought into it also. The judiciary's role is no longer just about punishment, as it was under environmental justice. Under climate justice, it is about ensuring survival, resilience, and fairness in the face of crisis caused everywhere. As a result, in Pakistan, the courts have held that government accountable for its inaction on climate change, emphasizing the need for comprehensive adaptation measures across various sectors. Courts in Pakistan have shaped adaptive climate jurisprudence, which is globally recognized now, issuing directives to government institutions to take concrete steps toward climate adaptation across various sectors. Our judgments were guided by the urgent need to protect vulnerable communities, ecosystems from the growing impacts of climate change. Now things change here. We've been giving directions for the last maybe 10 years now, thinking that our directions are being actualized and things are changing. But then the floods hit us in 22 and we realized that nothing much has happened on the ground.